Welcome to the third in the series of VWV's Procurement in Action podcast. I'm Stephanie Rickard and I'm going to be talking today with Ben Holt about the changes introduced by the Procurement Act in relation to the information to be provided to unsuccessful bidders, the standstill period and remedies for procurement challenges. We hope that the podcast will be useful for both contracting authorities and bidders.
And just by way of a reminder, we're only talking today about remedies under the Procurement Act 2023 and the Regulations 2024, which are due to come into force on the 28th of October. For any procurements that commenced on or after the 28th of October, those are going to be regulated by the Procurement Act 2023. So, Stephanie, we've seen a lot of new terminology that's going to be introduced by the new legislation. Could you just sort of run through some of the key changes in terminology that we need to be aware of?
Okay, yes, there's some important changes in this area. So the assessment summary replaces the standstill letter. And we're going to talk a bit more about what that looks like and the information to be provided. Now, the rather confusingly called contract award notice is in fact a new notice which is required to be published prior to a contracting authority entering into a contract, and it's a contract award notice that triggers the start of the standstill period. And then what used to be called the contract award notice is now called the contract details notice. So this is the notice that sets out that a contracting authority has actually entered into the contract. And one final change, when we talk about remedies, we often talk about ineffectiveness as one of those remedies, and this is replaced with the term set aside.
So let's drill down a bit more into each of those areas. What do we know about the assessment summary?
Okay, the assessment summary will need to be sent to all bidders before the contract award notice is published. And the information is set out in the Procurement Regulations 2024. And on the face of it, it looks a bit different to the information that you would normally provide under the standstill letter. So you have to provide a detailed breakdown of scores for the unsuccessful bidder, together with a detailed breakdown of scores for the winning bidder, confirmation of the contract award criteria that was used and the scoring methodology, and importantly, an explanation of the reasons for the score by reference to the scoring methodology. So in practice, the assessment summary is going to look like a short form version of the scoring sheet.
And what about the contract award notices? What information needs to be included in those?
So the contract award notice is a transparency notice which sets out details about the supplier to whom the contracting authority intends to award the contract, the route that was adopted to procurement, the estimated contract value, the date when the assessment summaries were sent out, and this is new, the total number of bidders, and if the value of the contract is over 5 million, there's a requirement to actually name the unsuccessful bidders. Something wasn't required to be disclosed under the current regime. So the reason for introducing a contract award notice is actually to provide bidders who decided not to participate in the procurement process, or if a contract award notice is issued following a direct award, to consider if the procurement rules have been followed, so it widens the range of potential complainants, if you like. Shall we talk about now the standstill period and some of the changes that have been introduced?
Yeah, under the new regulations, there's going to be a 8 working day mandatory standstill period. That's, of course, instead of the current 10 days that we have, 10 full days, not working days. The contracting authority isn't allowed to enter into the contract until that mandatory standstill period is over. And of course, provided that they haven't been notified that a claim's been issued. The standstill period will begin on the day in which a contract award notice is published. Note the change from the current position, which is the sending out of the standstill letter that triggers the start of the standstill period. It's also worth noting, I think, that under the new Act, it specifically refers to the period beginning with the day on which a contract award notice is published, whereas the old rule was that it's the 10th day after the standstill letter. So why does that matter? Well, essentially, day one is now the day of the notice, not the day after.
So Ben, one of the features of the current procurement regime is automatic suspension. Can you tell me how that works under the new legislation?
Yeah, sure. By way of recap, the contracting authority is automatically prevented from entering into a contract once it's become aware that the court proceedings have been issued to challenge a contract award. That's what the automatic suspension is. And in order to enter into a contract from that point, the authority would then have to apply to the court to have that automatic suspension lifted. The new legislation essentially specifies the test for the court to consider when hearing applications for the automatic suspension to be lifted. This new test requires the court to have regard to a number of things. The public interest in, amongst other things, upholding the principle that the public contract should be awarded and modified in accordance with the law, avoiding delay in the supply of goods, services or works, for example in respect of defence or security interests or continuing provision of public services. It's also got to take into account the interests of suppliers, including whether damages would be an adequate remedy, and a nicely generic any other matter that the court considers appropriate. We're going to have to wait and see how much this new test actually changes the position as it currently stands, which has been created through case law, essentially through the balance of convenience tending to lie in lifting the automatic suspension, as more often than not the court finds that damages are an adequate remedy for the claimant.
Okay, so the automatic suspension is a really serious issue for contracting authorities. Is there anything else that they need to be aware of under the new rules?
Yes, under the current regime, in order for the automatic suspension to apply, proceedings must have been issued. The contracting authority must have become aware of that being the case, and that must happen before the contract is entered into. Under the new legislation, in order for the automatic suspension to apply, proceedings must be brought before the expiration of the applicable standstill period. So there's therefore a slight narrowing on the existing remedy. We don't yet know for certain whether this applies to when the standstill period has been extended by agreement, which is quite often the case when there is a dispute. Usually the sensible thing to do, if it looks a legitimate dispute, is to extend the period, which is very short, to allow the parties to properly consider that and decide whether to either proceed to award the contract or to proceed with the claim. It's not just limited to the initial standstill period. Practically speaking, though, I personally can't see how it could possibly make sense for this not to apply to an extended standstill period. It doesn't specifically say in the legislation, but otherwise that's simply going to lead to a lot of protective claims unnecessarily being issued and lead to a lot of additional costs, including from the public purse, with people issuing claims within that 8 working day period. But as I said, it's not clear from the rules or guidance issued so far.
So this is an area that we would welcome clarity on in terms of whether it's actually possible to extend the standstill period, because that's a really important consideration,
absolutely.
Isn't it?
Yeah, there's also been a slight tweak, as you probably noticed, to some of the wording has changed to what on the face of it seems to mean the same thing, but has used different words. And this is another example. If you're paying very close attention, you'll have spotted that the authority must now be notified of the claim having been issued, rather than having become aware. And that might seem inconsequential, but I strongly suspect that there will be a case argued on that point. Lawyers will obviously argue almost anything. And it does beg the question as to why the wording has changed if it does mean the same thing.
So overall, I think the change to the methodology for calculating the standstill period is a good thing, because it makes it a lot clearer. What's your view of the changes to standstill?
I agree. Changing it to an 8 working day standstill period does probably simplify things in terms of the ability of the parties to calculate the period, but it potentially shortens the standstill period by a day, But on the other hand, it may allow for more time to consider a claim if the contract award notice is not issued on the same day as the assessment summary. As you said, Stephanie, the assessment summary needs to be issued before the contract award notice. It doesn't say exactly how long before. So to give a couple of examples, if the assessment summary was sent on Monday the 1st of July, that's the thing that basically sets out why you have won or not won. And the contract award notice is sent on Thursday the 4th of July. The 8 working day deadline to issue the claim to get the automatic suspension is going to be 8 working days from the 4th of July, takes you to Monday the 15th of July. So the bidder then has the best part of 15 days to think about a claim since it had the assessment summary on the 1st of July. If, however, the assessment summary and the contract award notice are both issued on the 1st of July, say with a few hours gap, the deadline will be Wednesday the 10th of July, so then the bidder would only have had 10 days to think about the claim.
Okay, so there's a real strategic benefit in thinking about when you actually send out your assessment summaries and contract award notice.
Yeah.
Okay, let's go on to talk about tweaks to the remedies. Can you talk me through the changes to the remedies available to suppliers? And we're looking at pre-contractual remedies here.
Yeah, I mean, the remedies are broadly the same as under the existing regime. They've just been made more express, I think. So if the court finds that there's been a breach and the contract has not been entered into, as you said, pre-contractual remedies, then the court may make one or more of the following orders. They can set aside the award decision. They can require the contracting authority to take any action. That could, for instance, involve re-evaluating. It can award damages and or it could make any other appropriate order, which is obviously pretty wide. So flipping it round, are there any changes to the remedies available where there has been a potential breach but the contract has already been entered into?
So there's been a lot of drafting changes here. As mentioned at the beginning of this podcast, the ineffectiveness remedy is now referred to as the set-aside remedy. However, the remedy of ineffectiveness under the current regime has 3 grounds, whereas the set-aside remedy has been extended to 6 grounds. Now, I'm going to talk about those 6 grounds and then look to see what's changed in practice. So, under the Procurement Act, a set-aside condition will be met if the court is satisfied that the supplier was denied a proper opportunity to seek a pre-contractual remedy because either the required contract award notice was not published, or the contract was entered into or modified before the end of any applicable standstill period, or the contract was entered into or modified during a period of automatic suspension or in breach of a court order. Then where you have got the case of a contract award where you didn't have to observe a mandatory standstill period, the breach only became apparent on publication of the contract award notice. In the case of a contract modification, the breach became apparent only on publication of a contract change notice, or the breach became apparent only after the contract was entered into or modified. So there's a greater emphasis, particularly in the last 3 conditions, on ensuring that the supplier has a remedy in circumstances where the breach became apparent after the contract was awarded, modified or entered into, i.e. where there was no opportunity to seek a pre-contractual remedy. Now, interestingly, what has been removed is the reference to calling off orders under a framework where there's been some irregularity. But actually, I think it is covered because in that particular case, if the breach only became apparent after the contract was awarded, then I think a supplier would be able to go back and claim under that particular ground. So I think that the new test actually catches a wider range of scenarios than the 3 tests previously. I know, Ben, that we've talked about slight tweaks to the time limits for bringing a set-aside claim. Are you able to elaborate further on that?
Yes, if the contract details notice, which was previously the contract award notice, which is now a completely different thing, was not in fact published, set-aside proceedings need to be commenced before the earlier of either at the end of the 30-day period beginning with the day on which the supplier knew or ought to have known of the circumstances giving rise to the claim, or the end of the period of 6 months beginning with the day the contract was entered into or modified. The wording again is slightly different to what we have for ineffectiveness under the current regime, in that the limitation period is now linked to the knowledge of the supplier, and it's therefore probably widened in the supplier's favour. Following on from that, are there any other differences that people should be aware of between the remedies of ineffectiveness and set-aside?
Yes, there's one important thing that's worth noticing. So currently, if an order of ineffectiveness is made by a court, it must be accompanied by a fine. But that fine or civil financial penalty has now been removed, which makes sense because the contracting authorities would be having to pay out of the public purse. So what can we say in conclusion in relation to this area?
I think, as I've mentioned, I think there's a lot of terminology changes which appear to be minor. On the face of it, they look like they do the same thing. I have strong suspicions that lawyers may be instructed and have, frankly, a field day arguing over what looks like semantics, but may not prove to be just a semantic change.
So do you think we're going to see an increase in the rise of complaints when the Procurement Act comes into force?
Yeah, absolutely, and some purely based on slight tweaks to wording, which, to my mind, could have stayed the same.
From my point of view, I think that there is an advantage in providing for assessment summaries to be sent out rather than a separate standstill letter, because in practice much of the information from the standstill letter had to come from the assessment summary. But one of my tips is for contracting authorities to think very carefully about the assessment summary and the amount of detail that is provided in there to make sure that it is compliant with law, but actually there's going to be quite a lot of additional information that's going to be disclosed, so there needs to be very careful scrutiny about the evaluation process. The other practical point is that time is already tight, as you and I know, for bringing procurement challenges, and it appears that the timescales are going to get even tighter.
Well, hopefully that's been useful for the listeners, and hopefully you'll tune in again for the next in the series. Thank you.